So thank you very much, Jessica, for inviting me to speak at the forum today. I'm very honoured to be in such esteemed company. As a practitioner, not an academic, who has to wrangle with making our very outdated and complex copyright regime work in our library to accomplish what we want to do for our clients, it's always very stimulating and encouraging to attend this forum. I've been coming for about 6 or 7 years now, and to be part of this conversation about copyright reform, and particularly about fair use. I'm here to speak about some work that the National and State Libraries of Australasia, so that's the National Library of Australia and New Zealand and the State and Territory Libraries here in Australia, has been doing, looking at collecting data on the costs of complying with copyright. My colleagues at the State Library of Queensland and my colleagues across all libraries have been, particularly in this discussion, digitising our collections and making them available online for many years, probably around 15 years. And over again, we've had conversations about the cost of complying with copyright requirements. And in particular, this is for works in our collections that might be socially or culturally significant, but which have long passed the time where they've had any commercial interest for any rights holders, or indeed may never have had any commercial interest for any rights holders, and which are also difficult or even impossible to clear for use, but which fall under the same sort of conditions as all of the other types of works. We're in the business of access, and we want to provide the broadest possible access to information, to our collections, to resources both online and in print, to our manuscripts, our pictures, our books, our e-books. We're champions of free access for citizens because we believe it fosters a more informed, educated and culturally aware society. But we're also champions of the idea of balance and fairness in copyright legislation. We want to protect the rights of creators, but also to uphold the rights of citizens to use and reuse information. Generally, as a profession, we're fairly risk averse, and we're very committed to being good librarians. We're very committed to compliance. We very much want the law to be fair and to reflect this idea of balance, which we believe currently is not. As a sector, we're very supportive of a fair use exception in the Act, and we'd also love to see the Copyright Amendment, Disabilities and Other Measures Bill become law, particularly as it would bring the duration of copyright protection for unpublished works into alignment with the protection for published works. And that, for us, would free significant parts of our collections, our original materials, unpublished collections, to come into the public domain and then allow us to easily digitise them. We've got lots and lots of anecdotal evidence. So get any group of librarians together and we will share copyright pain stories that have led us to hide under our desks in a fetal scream, moaning, why me, why me? My particular painful one is trying to clear copyright on the song I Met Her Monday on Thursday Island, that amazing song from 1953 that you all have a recording of. But unfortunately, this type of data, this anecdotal evidence, is not the sort that will win over legislators. In 2015, NASLA, the organisation of the state and territory libraries, received a request from ALIA, that is our professional body, to provide data on the cost of compliance with our legislative and regulatory requirements related to copyright in libraries. And that was for the purpose to support advocacy efforts for copyright reform. While that data was duly collected, the NASLA copyright group, to which I belong, noted some issues. Firstly, there was a lack of standard definitions that meant that the data could not be used to benchmark or make meaningful comparisons against other libraries. The ongoing and comprehensive monitoring of compliance costs is impractical, as it's very time-consuming, difficult to manage, and often lends itself to under-reporting. Anyone who's had to go through, a CAL audit or something like that will know that there's a great administrative burden with that type of work. And most importantly, we feel, the exercise failed to take into account that there are also costs associated with inaction, with not doing anything, with not clearing copyright, with collections that are deemed too difficult. We also recognise that the current fairly combative environment requires robust data and great strategic stories to advocate and drive the reform agenda. And so in 2016, the CEOs of the NASLA libraries approved a project for us, the Copyright Group, to develop a sort of a case study approach for assessing and reporting on copyright compliance, and a toolkit to provide a standard methodology and definitions to capture and compare these costs across our libraries. So the outcomes were that we now have a compliance toolkit for libraries. It's got a data gathering tool, it's got accompanying guidelines for staff who are doing the undertaking and recording of the data. It's got a data dictionary, and it's got an outcomes section for the inclusion of the final costs and comments that are related to the project. It's been designed to facilitate standardised data collection, simplified extraction and manipulation, and opportunities for robust benchmarking across libraries on the costs of compliance. The data then, we hope, can be used to craft strategic stories to highlight the need for reform and to support NASLA, ALIA and the Australian Libraries Copyright Committee in their advocacy efforts. However, the bigger issue remains. The costs of compliance for libraries are always greater than the costs that we can actually collect our data on, because a lot of the time, the work that we are doing, the works that we may want to digitise, don't even make it to the rights clearing world. Because identifying rights holders and negotiating the digitisation and online access, or establishing the orphan status of a work, is considered too onerous or complicated or difficult or time-consuming or resource-intensive to make it viable. With strained resources, many libraries still don't go beyond the low-hanging fruit of very easily cleared material. And because our institutions are fairly risk-averse, there's a reluctance sometimes to take a risk management approach, what I call the Nike principle, just do it. And to do that with collections which would have no adverse effect on the interests of the copyright owners, but which would make large amounts of Australian historical material easily available to use in ways which would enhance creativity, enhance knowledge, and national understanding of our culture and history. At the moment, we can't capture that data. And I think that's a significant deficit and something we need to work out a way of telling that strategic story, what's being missed. Every photo from 1955 to the present, which most of them are now orphan works that we couldn't possibly clear the rights on, is just one example. So what's next for us? The toolkit's now available online, and we would encourage all libraries to have a look at it and consider whether they may be able to collect data on their own costs of copyright compliance. Because if we gather together these strategic stories of what it costs us as a sector as a whole to make our cultural assets available, we may have a bargaining chip in the advocacy for fair use. And obviously developing a strategic story around the stuff that we can't have data on because we don't even bother. It's too hard. On a personal note, I think in this reform gap, as I like to call it, my personal plea, and I've got my own hat on here, is to increase significantly the use of Section 200AB in libraries, because it allows us to do some of these things, because it's slightly more principles-based than other exceptions, and I believe the experience in using this exception more fully and becoming very confident in the use of this exception should help equip us to understand how we can have confidence in the application of fairness factors should reform actually happen here in Australia, which I very much hope it will. So thanks very much. You can go to the NASLA website. There are my image credits because I like to be a good compliant citizen. You can go to the NASLA website, which is nsla.org.au, and just search for the Copyright Compliance Toolkit there, and I encourage all libraries to have a look at it and see if you could devote some time to doing a compliance cost checklist. Thank you.
Well, wait, before you run off.
Oh, okay.
Just checking if anybody has any particular questions for Margaret. We might do them from the floor, but it isn't interesting. Here we go. We have Kathy has a question.
I was just wondering if, in addition to costing licensing, there's also the question of
Yes, because it's the activities, the compliance activities we're looking at are very broad in scope. It's not just about rights clearing for works we want to digitise. It even includes the onerous work around document supply and document delivery and the requirement to file things by alphabetical listing of the person who requested it, and some of the really significant administrative burdens that exist in the current exceptions. Preservation and copying for people to look at the cost of them complying with the preservation copying principles, and also just those answering of copyright inquiries, which, it's certainly in my role, I would do half a dozen of those. Every couple of days I would do, where people are asking permission to use public domain works, and we've now gone so far as to have like a templated email response that says, we're really happy for you to use this. All we ask is that you attribute us as the source. You can buy you can download a high resolution for free or purchase one for print publication. Go for it. But I still have to do that at least multiple times a week. There's one there behind the pillar.
Oh, I couldn't see you.
For those who are curious about how some of these questions, particularly the questions about making collections that include significant numbers of orphan works available online, how those things might work out in a fair use jurisdiction, I would just call attention to a document that some of us in the visiting team worked on with experts as well from Berkeley a few years ago, which is the Statement of Best Practices in Fair Use for Collections Containing Orphan Works for Libraries, Archives, and Other Memory Institutions. And it isn't a statement of the law, but it's a strong consensus statement of what this institutional sector believes it can do, and is in fact doing, along these lines under a general fair use clause.
Currently, I think there's certainly the ADA is recommending that we use Section 200AB in the interim as far as possible to make a case for the digitisation of orphan works. It doesn't relieve us really of the burden of trying to work out of how much time it takes us to decide whether a work is actually an orphan or not, which is problematic.
Well, again, one of the features of interest of this document is that it hypothesizes that the analysis of orphan status that is involved in this process is one that should be possible to do at the box level rather than the item level. And that clears a good deal of the burden of item by item analysis out of the way. It was very clear that if we stuck with analysis at the item level, we wouldn't make any progress. So the argument of this document is for box level analysis.
And I would certainly concur, and certainly for us, it's almost even, we would almost sometimes, depending on the collection, look at a collection of letters and look at it from the collection level, not even a box level. So to be courageous with the use of 200AB, I think is something we can do in the interim. I think I might.
And just one last question I had, which was, is it up on the NASLA website? Is it going up?
It actually went up on the NASLA website this morning because NASLA met and endorsed it in Wellington only 2 days ago. So it's now available on the NASLA website.
But they can't find it, so we'll try to clarify that and tweet it or something.
Yes,
Send out to everybody.
actually I've got it in an email, so I'll tweet it if you like. Just follow me.
Okay. So thank you very much, Margaret.